The soft hum of whispers echoed through courtroom 6A as Anthony Reed shuffled through a thick stack of handwritten papers, his fingers slightly ink-stained from the hours he'd spent poring over them. He was a tall, quiet man in his early 30s, wearing a second-hand suit and square-frame glasses. To many, he looked out of place, a defendant representing himself in a case involving a complex dispute over wrongful termination, discrimination, and breach of contract. As he sat alone at the defense table, the prosecution side, led by sleek, suited attorneys from a prestigious corporate firm, smirked among themselves. One leaned toward the other and chuckled. "Looks like he brought his diary." Their laughter wasn't loud, but loud enough. Even a few courtroom spectators glanced over and snickered when they saw Anthony's overflowing binder, the tabs marked meticulously: case law, statutes, personal account, and rebuttals. The judge, an older man with a gray beard and a reputation for stern rulings, raised an eyebrow but said nothing. Anthony heard the mockery. He'd heard it before, on the job, in interviews, in coffee shops where people assumed he didn't belong in intellectual spaces. But what the courtroom didn't know was that Anthony held a master's in legal studies. He had been accepted into law school twice, but deferred both times to care for his ill mother. While working a custodial job at a corporate office, he spent his nights reading legal theory and precedent. He didn't just bring notes to court, he brought a legal thesis. When the judge called the session to order, the prosecution quickly launched into their opening arguments. Polished and rehearsed, they claim Anthony had been let go for performance reasons and denied any discriminatory practices. Their confidence was unshakable until Anthony stood and walked to the lectern with his binder in hand. "Your Honor," he began, voice calm and respectful, "I'd like to introduce this document as part of my opening statement. It's a comprehensive analysis of the policies cited in my termination, the inconsistencies in enforcement, and a comparative review of how those policies were applied across racial lines in the company." He handed the judge a copy, its cover titled, "An Examination of Corporate Discrimination Practices Through the Lens of Reed versus Hallman Industries, a Legal Thesis." The courtroom quieted. Page after page, Anthony laid out his argument with precision. He quoted labor law statutes, internal company memos, and precedent from federal discrimination cases. He cross-referenced depositions, even cited case law used by the prosecution, turning their own material into ammunition. When the lead corporate attorney objected that Anthony was getting too academic, the judge held up a hand. "He's within his rights and well within scope," the judge said, flipping a page of the thesis. "And frankly, this is more thorough than most motions I see from practicing lawyers." The laughter stopped. The tone of the room shifted. By the second day, the jury listened more intently. The judge began referencing Anthony's thesis during procedural debates. When Anthony cross-examined his former supervisor, his questions exposed contradictions so skillfully that even the stenographer seemed to pause in admiration. By closing arguments, the once dismissive courtroom now sat in stunned respect. Anthony concluded with a simple statement: "I may not wear the same suits or have the same degrees as the counsel across from me, but I know the law, I know my rights, and now so do you." The jury deliberated for only a few hours. They found in Anthony's favor on all counts: wrongful termination, discrimination, and breach of contract. The company was ordered to pay damages and issue a formal public apology. As the court adjourned, reporters approached Anthony. "Where did you learn to do all this?" one asked. Anthony smiled and held up his binder. "It's all here. You don't need a title to know the truth. You just need the discipline to write it."